Hello, teacher Lucia. I recording this video to try to explain what I understand about this article dealing with cross-cultural issues in court by Sandra Hale. First of all, I noticed that interpreters who work in community quite often confront difficulties like this when converting the source message to the target message, because basically of this kind of cross-cultural differences. And this subject has been a topic of debates and conferences around the world. It's a global issue for translators. Also notice that some interpreters show opposing views about these cultural aspects. In one hand, interpreters prefer do not involve, do not switch words from one language to another. And otherwise are those who advocate to be free to censor the content of they consider appropriate or relevant. To me, it's virtually impossible to apply the translation faithfulness to the practice, because language and culture are interlaced, and words and interaction only take on meaning according to context, the situation, culture, etc. Interpreters seems reluctant to offer clarifications in fear to generalizing or stereotyping or even overstepping culture, especially in legal settings. What more? This particular paper presents the results of tribunal members in Australia about interpreting practices in this type of settings. It means this kind of issues have been debated most of all in Australia. And this paper talks about the Australia courts and tribunal. Besides those issues, there are poor communication skills from the interlocutors and the interpreters' incompetence, perhaps, or unethical behaviors. The cross-cultural differences can be found also in people who speak the same language and who live in the same country. It means that there are subcultures within cultures. Socio-pragmatic differences, social conventions, perceptions, ideologies, beliefs, all matter in court interpreting, and always a challenge to interpreters. Overgeneralize could be a problem, because they are body language, physical contact, personal space. All this can confuse the judgment of interpreter and require knowledge in several cultures. In fact, unfortunately, there is a very little guidance and existing codes of ethics or other guidelines for interpreters in how to deal with such cross-cultural differences. If there are a way to overcome this dilemma, it's basically to be attentive to avoid misunderstanding and alert the court or tribunal about potential cross-cultural difficulties. In this, there other dilemma. how do intérpretes alert the court or tribunal? Interestingly, even among those who agreed that they would alert the court or tribunal, there was no consensus on how such a practice was to be implemented. With some kind of alert the presenting officer during the proceedings, or some wait until breaks and some making know the lawyers, prosecutors, or even the court officer. I don't know. There some kind of questionnaire when interpreters respond some questions about difficulties in court, and was basically developed to help them in this kind of issues. To me, these papers, these articles, brings to us a highlight about these major issues, these complexities surrounding cross culture, and this misunderstanding when interpreting process. Thank you.